What's going on, guys? New illegal news coming out of San Diego County today with a ruling out of the Superior Court of the State of California, County of San Diego, in the Central Division, which is the downtown area of San Diego. It was a order on application for temporary restraining order. So just a little background on what all this means right now is this group, which is right here, as you can see, all these, it's different groups. You got restaurants, you got gyms. That seems to be the two big ones. Is a lot of restaurants and gyms are suing Gavin Newsom and a lot of county officials. So what happens when you sue somebody is obviously you're bringing a cause or a claim that your rights have been infringed and that this other party has damaged you. Now, there's different ways you can get people to stop doing things while there's a lawsuit going. One of them is a temporary restraining order. That's the first equitable solution that you have. A temporary restraining order is basically going to the court and saying, look, this is an emergency. You need to stop the defendants from doing what they're doing right now. And if the court grants the temporary restraining order, then it's in place until there's what they call a preliminary injunction. Now, a preliminary injunction is a little bit more permanent. It lasts during the entire duration of the lawsuit. Basically, the court says, we're going to stop you from doing this damaging thing or this harmful thing to the plaintiffs. And that way they're not continually harmed while we go on with this lawsuit, because lawsuits could take a while. They could take years to resolve or finally get to trial. So the court has these mechanisms to stop the defendant from doing something harmful and make sure that the plaintiffs are basically just not completely irreparably harmed to the point where they have no more money or their businesses are destroyed. And that way they can at least have a fighting chance against the defendants. And when you're facing something like the government or the state or the county, that could very well happen because they have unlimited resources. They can fight you forever. These private parties will eventually start to run out of money unless they start to crowdfund or something like that. So what happened today was in San Diego County, this group of plaintiffs, who was a bunch of gyms and restaurants, filed this lawsuit, and they filed a temporary restraining order. So a lot of eyes were on the temporary restraining order to see what the ruling was, because that will give you an indication of how this case is going to go and where you think the judge is going to land. Now, I don't know anything about Kenneth, the Honorary Kenneth Medell. I haven't appeared before him, so I'm not sure what he's like. I haven't read up on him. But we're going to look into his order and some of his explanation of what's going on. So a little backstory, these groups, these plaintiffs sued the state because San Diego was thrust into the purple tier. The numbers, however, don't show that a lot of gyms and restaurants are contributing to the cause or spread of or the rise of COVID-19 in San Diego County. So what they're basically arguing is you're punishing businesses that are not really contributing to the spread. And the state is arguing, well, we could do it because we have these studies to back up, yada, yada, yada. We'll get into it. The numbers, especially for the gyms, are really low. Almost, they're under a percentage point. So we're going to get into that. Going to explain really what's going on here and what's going on going forward. So we'll get through all of this. This is all just background information, factual allegations. It's talking about what happened. They're basically suing based on the color-coded chart of confusion that I like to call it, because no one really seems to know what's going on or how you get in or out of these. So that's where it is. Right here, plaintiffs allege that the San Diego County's recent increases in the case rates are not due to sector closures. According to plaintiffs, there is a minimum COVID spread in these sectors. So you have restaurants and bars that were 7.4% of any of the cases. That's 714 out of the 9,646. And gyms were 39 out of almost 10,000 cases. Now, how they do this, I'm not really quite sure what the contact tracing is. I think it's when you test positive, they ask where you've been, and they just kind of attribute that you were at this place, so you may have contracted it there. I don't know if that's really exact science, but I'm not a scientist. I'm just an attorney, so that's what I'm here to talk about. They also go on to state that in the previous 3 weeks, 25 to 30% of civilian hospital beds have remained available. ICU beds were available at 30-40%, below rates considered problematic. More than 80% of hospital beds or hospitals had 21 days worth of PPE. The county of San Diego bought hundreds of millions of medical-grade gloves and have secured contracts to provide for additional respirators. So basically what they're arguing is that the numbers are really low. We're not contributing to it. And if your whole thing is we want to slow the spread, because we got to flatten the curve to slow the spread because we don't want our healthcare to be overwhelmed, then it doesn't really, they're making the argument, it doesn't really add up, because if we didn't add to the spread and we have plenty of hospital beds and we have enough PPE, or PPP, is a PPP, yeah, personal PPE. PPP is the loans, PPP, PPE, too many acronyms with lots of letters of P in it. And they're saying basically the healthcare system is fine, it's ready to go, we got enough stuff, and we're not contributing, so why are you punishing us? Another allegation they make is that plaintiffs allege that the governor's blueprint lacks a path to a green tier. In other words, the identification of criteria that would allow a return to pre-pandemic conditions. They allege that neither the governor nor the California Department of Public Health, that's what CDPH means, has articulated a plan to rescind the state of emergency. Thus, plaintiffs allege the plan could not lead to terminating the state of emergency at the earliest possible date, which, according to First Amendment complaint, is violation of Government Code 8629. We've talked about that before with the emergency powers, and we'll talk a little bit more about it and what that means. So basically what they're alleging is that Governor Newsom's actions are ultra vires, which is Latin for beyond their legal authority, and exceed his statutory authority. So they're basically saying the creation of the blueprint. Now, the Pacific Legal Foundation also has a similar lawsuit going on right now, stating that the blueprint that he's created is basically outside of his authority that has been granted on the Emergency Services Act. But this one is just specific to San Diego, that was just filed. This is more about the background. Don't really want to get into that. That's just all background. This one point I want to point out, the methodology employed by defendants in making their tier assessment bears no relation to the actual risk posed by plaintiffs' industries if they should remain at their open at their current capacity. So again, that's what they're arguing, is that we're not cause for the spread, so why are you blaming us? Obviously, the state came in, the Attorney General's office, because it said it will disrupt the state's health-based, data-driven reopening framework designed to slow the spread of COVID-19, particularly in the midst of an unprecedented surge of the virus, and because plaintiffs' legal claims lack merit. So they keep going this health-based, data-driven reopening, even though the plaintiffs are showing that the data doesn't really add up, that if they're not causing the spread, why are they being punished? According to the defendants, the separation of power does not require hermetic sealing of government branches from one another. By enacting the Emergency Services Act, the legislature made the fundamental policy decision to confer on the governor the authority to make orders necessary to carry out the provisions of this chapter. Now, I've discussed the Emergency Services Act before, and I'm going to say this right now. There are a lot of people out there I see flying around social media making this claim, and they say you don't have to listen to what comes out of the Emergency Service Act because it's not law. And I have disagreed and told you numerous times to not listen to people who, one, are not attorneys, who don't really understand what's going on. Not that you don't have to be an attorney to understand the law, but to make these sort of deductions, that's not true, because what they've done is the legislature has given the power to the governor to make these orders. And it's the same thing with the Health and Safety Code, which they bring up. Basically, you can, as the legislature, say on law, okay, here in this instance, we're going to give the governor X amount of powers. And in this case, that's what the Emergency Services Act is. I just wanted to clarify that because a lot of people say, oh, these closures are not law. You don't have to listen to them. The legislature didn't pass them. No, but the legislature passed a law that effectively confers power onto the governor to make these decisions. So it still has the power of law because it's backed by law. So I just want to make that clear because a lot of people throw that around and say that that's not true. It absolutely is true. They do have the power. The real question is how far they go, and that's really what a lot of these lawsuits are arguing. Defendants continue to argue the purple tier is not outright prohibition on operation of businesses like restaurants and gyms, but only imposes restrictions on them. Without minimizing the impacts to the plaintiffs, defendants believe that the harm to plaintiffs is outweighed by potential harm to public health from an injunction that effectively dismantles a significant portion of the state's COVID-19 response. So that's their argument. Now, this is where we start to get into the order. This is where the judge and the court this is where they get into their rationale. And some of it is, I'm going to tell you right now, it is pretty frightening. The way I look at it as an attorney, what they're kind of setting up. And if this is sort of where judges are going to go, this is going to be a problem with us litigators who are kind of fighting this stuff out in court. We've got a long uphill battle against us, but I think, there's a lot of lawsuits going on out there, different arguments and stuff like that. You may just get the right judge and the right argument and the right set of facts. So you just got to keep trying. So the court finds that there's no question that movement to purple tier will have a negative impact on plaintiffs and similarly situated businesses. Well, that's good that they recognize that. The court accepts the harm as described in the declarations of these people. The court understands the specific hardship of Cowboy Star Restaurant Fit Gym that may not be able to expand outdoor operations. If you don't know, Cowboy Star Restaurant is a fancy steakhouse, so it's kind of hard for them to continue doing it. And Fit Gym basically has all their stuff inside, so they can't move a lot of their stuff outside. There are real economic consequences to workers in these businesses whose employment is threatened. The role of the court for purposes of injunctive relief is to balance this very real impact with the impact the defendants will likely suffer. So that's what you do when you go into a TRO situation. It's an equitable solution. And what that means in court terms is you have to make sure in an equitable solution, you're balancing the harm and the protection on both sides. You don't want to unduly harm one side, and then at the other side, you don't want to you don't want to unduly harm the other side. You don't want to overprotect the other side. So it has to make sure, the court has to look at it and say, is there an equitable solution here to make sure both sides aren't harmed? The role of the court for purposes of injunctive relief is very real impact. The impact the defendants will likely suffer. Moving down. Then they go on to these primarily three factors, and basically what they know, that the stay-at-home orders and restaurant closures meet these factors, and use masks meet these factors. And thus, closures or other restrictions on businesses are an important factor to reduce the number of interactions and in turn reduce community spread. In the court's mind, the impact on public health of dismantling a portion of the state's COVID-19 response designed to reduce community spread outweighs the economic harm to plaintiffs, at least pending further examination of these issues in any upcoming hearing on preliminary injunction. So, what the court is saying here is right now at this temporary restraining order stage, they don't want to issue a restraining order against the state because they're not overwhelmed or blown away with the evidence and the arguments that they see at this point. So they see that getting rid of or enjoining the state and the county from issuing or stopping these orders would cause more harm. So that's their argument there. Now, this is part of more court procedure. Now they go to a preliminary injunction hearing. So at that point, they can prepare and bring up new experts, and they can bring up more evidence at the preliminary injunction hearing. You could sway the judge, but usually the temporary restraining order is giving you a good sign of where the judge stands. So you kind of can see, do you have an uphill battle, or do you have, is it looking good for you? And at this point, it's not looking good. Then he goes into probability of success, because there's these elements that you need to meet for a temporary restraining order as well as a preliminary injunction. Probability of success is one of them. Keeping going down, he talks about whether the Emergency Service Act violates the California Constitution. This is something a lot of people have been talking about. There's a lot of arguments that are out there in lawsuits. And the court says here, neither the law nor the evidence before the court at this preliminary stage gives rise to finding a reasonable possibility prevailing on the claim that the California Emergency Services Act is unconstitutional. That's definitely a hard question to answer, because the Emergency Services Act is not only dealing with pandemics, COVID-19, what it's also dealing with, especially here in California, is wildfires, earthquakes, stuff like that. So there's a lot of stuff, or water drought, there's a lot of things that could happen here in California. And the governor has to be able to kind of step in and marshal his agencies to kind of address these issues. So that's kind of a hard argument to make, to say that the California Emergency Services Act is unconstitutional. That's definitely a moonshot for these attorneys. And I think they could have been a little bit maybe more nuanced instead of just saying the entire thing is unconstitutional. The section provides, and this is Government Section 8267, basically the Emergency Services Act, that the governor may make, amend, and rescind orders and regulations necessary to carry out the provisions of this chapter. The orders and regulations shall have the force and effective law. So like I said, A lot of people who think that any of these orders from Gavin Newsom are not law, they do have the effect of law. So right there, for all those people who are telling you don't listen to Gavin Newsom because it's not law, well, that shows you that it is law. You know, I hate to say it, but it's just, I'm telling you the true facts that it is what it is, that they have the effect of law. And it goes on to talk more about the Emergency Services Act. And it basically talks about how he can marshal all of his agencies. So you have all these different agencies under the executive branch. The governor can kind of marshal those resources to address it. Plaintiff's argument is that there's no safeguard in the actual blueprint to allow for early termination. However, nothing in the act itself requires the governor to explicitly set forth when the emergency declaration will end. Nothing in the article precludes from explicitly indicating it will trigger termination, but nothing in the act requires the governor to do so, and this is scary. Given the circumstances the pandemic may mutate, evolve, or unexpectedly worsen, there may be good reasons why the governor is not required to articulate explicit emergency termination triggers. What they're arguing there is that, well, why, things change in a pandemic, so he doesn't have to tell you when it's going to end. Basically, that he's not required to because a pandemic can go up and go down, and he has to be ready for all of it. This goes on to talk about more, and this is really their conclusion. The blueprint for safer economy is such an order taken to prevent the spread of an infectious disease. So right now we can see that the judge is a fan of the blueprint. He thinks that it does prevent the spread of any infectious disease. So it's not looking good for the plaintiffs right now. This point I thought was very concerning to me. Plaintiffs argue that industry closure is not part of that grant of authority. First, the court does not view the exercise of power here as a, quote, industry closure. This argument confuses impact with the actual exercise of power. The blueprint for a safer economy directs the degrees to which different kinds of businesses and institutions can remain open in the county. So they're trying to argue basically that even though the fact that we've basically destroyed your entire business to the point where you can only operate on this one little sliver, it's not industry closure technically because we haven't closed your industry. So that's scary that the court thinks that way. That in essence, if they're looking at this from an equitable point of view, they're not seeing that, well, you're effectively and equitably closing these businesses down because they can't operate. So, for example, like Fit Gym, no one's going to Fit Gym because they can't operate indoors. So now you can't operate indoors. They're going to have to put all these gym memberships on hold. Basically, they've lost their entire business. Their whole business model is destroyed. It's basically like saying, oh, if you're a water tour company, now you can't do the tours on the water anymore. You have to do them on land. It doesn't mean we closed your business. We just have to tell you have to do it on land, which is not feasible because that's their whole business model. While businesses may suffer adverse consequences as a result, the actions are not industry closures. So again, they don't really see that as an industry closure because they're kind of the judge is looking at this, I think, a little bit too critically. And, almost literally in the sense that the equitable argument, again, is that they have effectively destroyed or closed their business. And while they can say in cute political terms or in legalese, well, we haven't closed your business because you can operate outside, the effects is that you have effectively closed my business. You've ruined what is my business model. They go on to say, plaintiffs argue that defendants must evaluate the current spread within each business sector, such as restaurants and gyms, in each county, rather than as defendants have done, develop a general statewide framework targeted at slowing community spread across sectors based on the current epidemiological conditions prevailing in a county, as described by Dr. Michael Soto in his declaration. Now, remember back when, I'm old enough to remember, that in the beginning, Governor Newsom actually had it this way, that he was going to basically have the state oversee a lot of the counties and then let the counties do what they need to do to reopen. They can kind of look at what's going on the ground. They can respond to things a lot faster in the state. And obviously a statewide ban on stuff is hard to enforce. That was the beginning. That was what Newsom did in the beginning. He backed away from that and did this whole phase and blueprint thing now, and he kind of took it all himself. I don't think that's a pretty good argument to make, that there is a better solution. So when you're arguing in front of the court, you do want to make that that kind of open to the court and say there are more rational and equitable solutions here, which is allow the counties to figure it out on their own. If the county looks at it, and we'll get to this next quote down here in a second, if the counties look at the different sectors and say, well, gyms are doing fine, they're not really contributing to anything, well, then let gyms stay open. And that should be a county decision. Or if the restaurants aren't really contributing in that county, don't close the restaurants. And it's really up to the counties to kind of keep things under control themselves, as opposed to someone in Sacramento who's 800 miles away and doesn't really know what's going on. Plaintiffs bring out at the time of the request for adjudication, Dr. Wooten, who is San Diego's head of public health, offered the data to show that San Diego County gyms, restaurants operating indoors under red tier did not cause or significantly contribute to the recent spike in COVID cases. Therefore, in Dr. Wooten's judgment, at the particular time, it was safe to allow these sectors to continue inside operations. So basically, Dr. Wooten, in her own words, said they're not contributing. And I think she was kind of on the side of maybe we shouldn't punish these businesses. So as much grief as she's been getting, importantly, the court's function is not to decide between two rational scientific or epidemiological arguments and decide which one court prefers, only if there is no rational basis for the action taken to intervene, particular Governance Act, and blah, 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 blah. So this is, again, where I think the court is just basically punting and saying let the state do what it wants. Because the court can have the power to say this is not rational. I mean, the plaintiffs have presented their arguments, they've presented the data, and they've shown that San Diego County is doing what it's supposed to do, and these particular businesses are not contributing. The court can step in and say, yeah, it seems rational to me. And rational is a pretty low standard in court terms. Rational is basically, do you believe it is? Yeah, okay. Rational is pretty much always passed when it comes to a rational basis test. But they're not going that way. They're saying the state can basically do what it wants, and we think that we have no reason to intervene. Well, actually, the courts have a very strong reason to intervene, is because a lot of these, you can't just take the state at its word. You kind of got to look at this from the court's perspective and check the executive branch and say, we're the check on the executive branch. We're the third branch of government. We're here to make sure that what you're doing is rational. And the court is basically just punting on this. They say, well, we don't see that it's not rational. It is true that the state never submitted its brief nor was able to articulate at oral argument the specific rationale behind the state's rejection of Dr. Wooten's scientific argument and adjudication request. So, even though they didn't present any rational argument, the court still said, yeah, it's good enough for us. We'll keep going for it. So even though Dr. Wooten says a rational approach would be not to punish these businesses, even though they present the data to show that it's not rational, and they provide studies and declarations, the court says, well, yeah, we don't see that it's not rational to continue to do this. Even though they have the power and an equitable solution to come up with what is a rational solution. It goes on to say, and this is their final order, this is basically their summation. This undermines the finding that at this time the state order in question is arbitrary and capricious. Arbitrary and capricious is kind of a hard bar to meet, but anyway, so that's where we are right now. Where are we going from here? They have a preliminary injunction hearing that is going to be coming up. I don't know when that's going to be coming up. Usually temporary restraining order is an emergency order, so they schedule it right away after the filing of the lawsuit. They want to get that done and over with. And then a preliminary injunction is down the road. So there may be more time for the plaintiffs to come up with more arguments, more studies, more declarations, expert witnesses, stuff like that they can present at this preliminary injunction hearing and maybe sway the court. But right now it's not looking good. It looks like the judge in this case is, and this is really a frustration I think a lot of attorneys and litigators are having right now, is the court is not doing its function. As Justice Alito said, it's up to courts to kind of step in and make sure these governments are not running wild. And right now, courts are not doing that. They're just kind of punting on all these things. They don't want to get involved. I think it's probably dangerous to them. Maybe the public pressure of kind of striking down any COVID restrictions means that someone's going to dox them or intimidate them or something like that. The public pressure might be too much that a lot of judges are just saying, I'm not going to touch it. It's the third rail of law right now. But like I said, there's a lot of attorneys out there who are filing lawsuits, different arguments. You never know. Pacific Legal Foundation suing on the same thing. They may be lucky. These people, I think, are going to continue suing. So we'll keep our heads up and keep pushing forward, because the more lawsuits are out there, sooner or later, one is going to get through and one's going to set precedent, kind of like Kevin Kiley and James Gallagher. So with that, I want to give you an update on sort of this new court's ruling with this temporary restraining order. And so where this is going to go from here. And yeah, that's my thoughts. So until next time, thanks a lot.